Ready? All right, well, good morning. Thank you for taking the time to come and visit with us today on this important announcement. Almost 5 years ago to the month, under my leadership, this office intervened in 39 coastal permit lawsuits which had been filed throughout 3 different parishes, Cameron, Jefferson, and Plaquemines. At the time, the industry was threatened with continuous fragmented lawsuits. Understanding that increasing the number of suits in multiple parishes and multiple appellate districts, we believed it was necessary to intervene to ensure a fair and orderly resolution of claims and to halt the growing number of new lawsuits. During that time, 5 years ago, my comments on the intervention to you all were as follows: that the people of Louisiana are facing some very difficult challenges, that our state government at the time was grappling with budget issues, our industries were struggling and still are to create jobs, and our coastline continues to wash away. These tribulations require enormous public policy decisions. It is critical that these issues are resolved with the best interests of our constituents in mind. Again, at that time, I said, continuing to allow individual parties and parishes to steer public policy, the public policy of Louisiana regarding our coastal restoration and protection was, and still is, unhelpful. Doing so allows differing and competing interests to push claims which collectively impact the public policy for our coast and our entire state. Louisiana's public policy should be dictated by the rule of law and those elected to execute that policy. At the time of the intervention, the intervention was about protecting the rights of the people to direct public policy through their duly elected officers, while ensuring that the state's coast is sustainable. I have always believed that we can balance the tremendous benefits of the oil and gas industry, which continues to employ thousands of our people, and the ongoing coastal crisis, which threatens Louisiana's very existence. At the time, this was not an easy decision, but even then, I knew it was an important one to make. From that point on, 5 years ago, I openly communicated with the industry and informed them that if they believed it was in their best interest to fully litigate these cases, then I would support that position. If at any time they wanted to resolve this matter apart from litigation, I would be willing to assist if and only if the resolution addressed several criteria. Number one, it must be good for Louisiana and productive for the coast. Any monetary amounts must be spent on the coast and consistent with the state's master plan. It must contain some sort of regulatory or credited relief for the industry. And it must be final and create certainty for the industry moving forward. Our actions on these suits are designed to bring finality and resolution and allow everyone a seat at the table. While I've always maintained that these suits are counterproductive to job creation in the energy industry, it is still my responsibility to listen to all sides. When a party to litigation comes to the table with a request to resolve the matter, apart from that litigation, as a lawyer, I have a duty to listen. Let me be clear. My actions today should not in any way be construed as pressuring any of the parties still in litigation to resolve these matters outside of litigation. My position has not changed. I am hopeful that whatever the outcome, we can find a way to preserve our coast and continue to grow an industry that has been the lifeblood of this state. I still maintain my belief that the federal government, through the Army Corps of Engineers policies, has continued to be a major contributor to our coastal problems here in Louisiana. That is why this office continues to look for ways to hold the U.S. Corps of Engineers responsible for the failure to address their inefficiencies. The resolution put forward today has the means to meet the criteria that I spelled out earlier. It is important that everyone understand that this resolution is contingent upon legislative action, which I believe is paramount to this agreement. This allows the people's representatives to have their say in shaping a resolution. The resolution actually works as follows. Freeport and the state enter into an MOU, which we did today. An initial payment of $50 million by Freeport is deposited into an escrow account. Additional annual payments are made contingent upon legislative action. If the legislation passes, additional payments by Freeport of $4.25 million per year over the course of the next 20 years are made. If environmental credits are sold, a dollar-for-dollar reimbursement is made to Freeport as funds are available. The legislation proposed in the MOU, the legislation is basically would authorize CIPRA, the Coastal Protection Restoration Authority, and the parishes to receive funds from this agreement. The legislature will create a board or decide how to implement the usage of these funds, but it must be consistent. Again, it must be consistent with the Coastal Master Plan. The legislation will also create dedicated funds to receive these resolution dollars in order to finance the coastal projects. I believe that we can get to a place where everyone works together to protect our coastal communities and focus on what really matters, which is preserving our coast for our children and grandchildren and ensuring that Louisiana's oil and gas industry and our #1 job creator is able to thrive here in this state. Thank you, and I'm happy to take any questions you may have. Mark?
The oil and gas industry already has sent out a number of statements saying that they oppose this settlement. What say you?
Well, look, I can certainly appreciate that. Again, if they want to continue to litigate this matter, I certainly stand by that decision. I'm not critical of it. This is one party in the lawsuit. And many times, you know, Mark, people have asked as we continue to look through this particular agreement, you know, why are you, agreeing to this? As a lawyer, it is our responsibility to look for ways in order to settle matters absent litigation. That's the #1 rule of a lawyer. And when parties come to the state asking to resolve those matters, it's our duty to do so. And so the other parties in this litigation, if they're not interested, like we've said at the very beginning, I continually support that position and we can litigate this matter.
And would the legislation encompass all of the other parties in this?
No, it doesn't. This legislation basically is required under the MOU that we're signing.
Are the parish presidents going to have to sign off on this for it to become active?
It has always been my position that these are, and the statute is clear, that these are state claims. The parishes are not in any way required to execute these documents. Now, whether Freeport requires or is demanding that they settle is a different story. That's contractual, right? But as a matter of law, these are state claims, and we absolutely, this office, me, the buck stops with this office as the chief legal officer for signing these types of agreements.
And as you said, the other parties wouldn't be forced to join, but does this create in your mind a potential template to resolve some of the other suits if the parties would agree?
Look, that's going to be dependent upon what the legislature does. Again, one of the things that attracted us to this agreement is that this is not an agreement under which DNR says, yes, this is good, which they have. They signed off on it before we took a look at it. And then we said, oh yeah, and then it's done. What's great about this is this actually places this agreement, the finality or the ability to execute this agreement, in the hands of the people's duly elected representatives.
For the terms of the settlement itself, in terms of what was worked out between the parties, is that going to be public?
The document, we executed the document. The document, in my opinion, is now a public document. Did you have a question? Okay. Any other questions?
Well, can I ask on a different issue? Where are you with June Medical? I understand that the attorney disputes are being negotiated now.
Yeah, look, I'm sure as you're already aware, and as you mentioned, that we're currently in mediation with them, and those are good faith negotiations that are ongoing. And in order to ensure the integrity of those negotiations, I won't make any further comment. People forget that we didn't bring this to the Supreme Court, they did. We won the case at the Fifth Circuit. So I have a constitutional obligation to defend the laws of the state and the actions of the legislature. And so I take that obligation very seriously. And so as long as I'm the Attorney General, Mark, we're going to continue to defend the laws that the legislature passes.
Are you far apart, or is it close?
I can't comment on that, but I appreciate you asking.
So the industry, as you know, the industry has complained oftentimes that the whole idea of these lawsuits has a chilling effect on investment in the state. And you apparently share some of those concerns. You've talked about it. So do you have any concerns about negative effects on the industry of this settlement going forward?
Well, honestly, I don't know if the negative effects that are occurring on the state can get any worse. I can put it to you that way. This litigation has been going on for over 8 years now. It continues to have a chilling effect. I continue to share, along with the industry, ways to be able to resolve these matters or to take these things off of the table. Look, I want a big sign at both ends of I-10 and then on I-20 as well that says, we welcome the oil and gas industry and the jobs that it creates. Okay, thank you. I appreciate your time.